there a reasonable probability of the jury reaching a verdict within a reasonable time as to all of the counts?
No.
All right, so jury number 12, I'm going to have you leave the courtroom. At this point, there shall be no further deliberations, so we leave the instructions. You be seated. So, the answer was, from the court's question, was consistent with the note. There are several options at this point. The court is inclined not to further poll the jury for reasons I stated before. But I want to hear the thoughts from the parties. Mr. Jackson, I'll start with you.
Your Honor, at this point, I think the court should take the verdicts that have been decided upon. I don't, from the note and the response of the presiding juror, I don't think additional deliberation on as to count one as to each defendant is going to prove fruitful.
Is there an agreement from the state to declare a mistrial on counts 1A, counts 1 for both defendants?
Yes, based on the juror's response that they cannot reach a verdict, I believe that is the position that we're in.
All right, Ms. Coe?
I'm in agreement.
Mr. Trail?
Yeah, what is one? I don't have my packet with me. Is that assault 2 with a deadly weapon?
Mr. Graham, my understanding is count 1 is the assault by the police car.
Yes.
Yes.
The alleged assault.
Okay.
My apologies.
Okay. That's the only clarification I want. I'm in agreement.
Okay. So at this point, based upon several factors, number 1, the strength of the note. Number 2, the answer from the presiding juror. Number 3, the duration of deliberation, which at this point is in day 5. The court is inclined to the agreement of the parties, declare a mistrial as to count 1 for both defendants, and is inclined to take the verdict on the counts remaining. So what I'd like to do is bring the presiding juror in and give her the instruction that they are to complete the paperwork on the counts upon which they have agreed, and to so notify the bailiff, and we'll take those verdicts that have been reached. Mr. Jackson, your thoughts as to the procedure?
I agree, Your Honor.
Ms. Coe?
I agree.
Mr. Trail?
Yes.
All right, so let us bring the presiding juror in one more time. All right, please be seated. Juror number 12, welcome back to the courtroom. At this time, the bailiff is going to take you back to the jury room. I'm going to instruct that you complete the paperwork on the counts upon which you have agreed, and so notify the bailiff. And when you notify the bailiff that the paperwork is complete, we will have you return to the courtroom with all of the jurors. So, a couple of announcements. First of all, will there be a desire from the lawyers to talk with the jury? Mr. Jackson?
Yes.
Ms. Coe?
Yes, Your Honor.
Mr. Trail?
Yes, please.
Okay, so my typical practice is to go back and talk to them myself. They obviously have an option not to talk to me. They have an opportunity not to talk to me and not to you. So they will be given that opportunity. In a case like this, I'm not sure what the answer will be. There may be 12 people.
Erik is completed.
may be 12, there may be 0. But in any event, after my discussion with them, I will come back and lead, if there are jurors left, the attorneys back to the jury room for that discussion. Second, I'm going to make this announcement to everybody in the courtroom. This trial has required restraint from those who have watched it. Now is a time in which that restraint will be important as well. There shall be no outbursts of support or disappointment, approval or disapproval of the verdict. If you are unwilling or unable to commit yourself to no outbursts, we have Courtroom 101, which is next door. It is available to you, and this process will be videoed, or not videoed, it will be available to you in closed captioning to watch it, not closed captioning, just by video, to watch the verdict if you are unable to commit to what is required, which is no verbal outbursts one way or the other. At this point, let's bring the jury in. Please be seated. Ladies and gentlemen of the jury, welcome back to the courtroom. We have been informed that there are verdicts on some of the charges. Juror number 12, are you holding the verdicts?
I am.
Can you please hand them to the bailiff? Thing I'm going to do is review them myself to see if they're in the proper form. Determined that they are in the proper form. I'm now going to read the verdicts. Verdict with respect to State of Washington versus Andre Damon Thompson, verdict form 1A and verdict form 2A are left blank, based upon previous discussions with the parties as well as previous discussions with the presiding juror. The court is declaring a mistrial as to counts 1, as to State versus Andre Damon Thompson. As for State of Washington versus Andre Damon Thompson, cause number 15-1-1262-6, verdict form 1B, left blank. As to State of Washington versus Andre Damon Thompson, verdict form 2B. We, the jury, having found the defendant not guilty of the crime of assault in the second degree as charged, or being unable to unanimously agree as to that charge, find defendant Andre Damon Thompson guilty of the lesser crime of assault in the third degree, dated today's date, signed presiding juror. As to the State of Washington versus Bryson Tyler Chaplin, verdict form 1A and 2A are left blank, based upon previous discussions with the parties as well as previous discussions with the presiding juror. The court is declaring a mistrial as to count 1 for Bryson Tyler Chaplin. As to State of Washington versus Bryson Tyler Chaplin, cause number 15-1-1263-4, verdict form 2A, left blank. Verdict form 2B, we, the jury, having found the defendant not guilty of the crime of assault in the second degree as charged, or being unable to unanimously agree as to that charge, find the defendant Bryson Tyler Chaplin guilty of the lesser crime of assault in the third degree, dated today's date, signed presiding juror. Verdict Form 3. The State of Washington versus Bryson Tyler Chaplin. We, the jury, find the defendant Bryson Tyler Chaplin guilty of the crime of assault in the fourth degree as charged in count 3, dated today's date, signed presiding juror. Is there a request to poll the jury?
Yes, Your Honor.
Okay. So, ladies and gentlemen, there's another step in this process, and that is called polling of the jury. This is where the clerk will ask you, each one of you, 2 questions with respect to these verdict forms. The first question will be, is this your verdict? The second question will be, is this the verdict of the jury? To each question, you must answer yes or no, and no other answer. Madam Clerk?
Juror number 1, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Bryson Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Bryson Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 2, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Bryson Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Bryson Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 3, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 4, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury? Yes. Juror number 5, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 6, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 7, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 8, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 9, as to defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to Defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 10, as to Defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to Defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury? As to Defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 11. As to Defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to Defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to Defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Juror number 12. As to Defendant Thompson, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to Defendant Chaplin, verdict form 2B. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
As to Defendant Chaplin, verdict form 3. Is this your verdict?
Yes.
Is it the verdict of the jury?
Yes.
Ladies and gentlemen, thank you very much. That will conclude the polling of the jury. I am satisfied that these are proper verdicts, and I will instruct the clerk to have them filed. For 9 weeks now, you have been under my instructions not to talk about this case, not to let anybody talk about this case with you. You are very nearly done with your service to this trial and to this case. I will, after a few things here in the courtroom, I will be back to have a conversation with you all about your jury service. You are very nearly released from my instructions. And you may now discuss this case and your jury service with others, including attorneys involved in this case, if you wish. You are not, however, required to do so. You have the right to choose not to answer any questions about this case, whether the questions are asked by the attorneys or anyone else. You may choose to answer some questions and not others. For example, some jurors choose to talk about what happened in the courtroom, but not about what happened during deliberations. The choice is entirely yours. You should be considerate, however, of the privacy interests and expectations of your fellow jurors. In particular, do not reveal other jurors' names, addresses, or telephone numbers. So, ladies and gentlemen, as I mentioned, I will be back after a few moments here to answer whatever questions I can and talk with you about your jury service. You're not obligated to be there if I get there. I do want to pass along this. This has been a very long trial. 9 weeks you have been under the court's instructions not to talk about the case, and for 9 weeks you have put your lives on hold and given your service to this county and to this case and to this court. I want to thank you very much for that. It's not easy being a juror, and you all have done your duty. Thank you very much. I hope to see you. If I don't, thank you again. Please be seated. So, with respect to for the motions and sentencing, Mr. Jackson, what's your proposal?
Your Honor, the state is asking the court to remand each defendant into custody after conviction pursuant to Criminal Rule 3.2F. The court can, after conviction, revisit the conditions of release. Sentencing, I think, is going to be a little more complicated as to the date. I know Ms. Coe is leaving for some period of time. I haven't heard, or I don't recall when she's going to be returning. Certainly, we could work with the court's judicial assistant as to setting a sentencing date, unless we can come to some sort of agreement. I haven't spoken to Mr. Trejo about his scheduling issues either. But that's the state's motion to remand into custody pending sentencing.
All right, Ms. Coe?
On behalf of Mr. Thompson, the defense has strongly opposed that. Mr. Thompson has appeared for each and every court appearance today was the only date that he was even remotely late. There is nothing to suggest at this time that he is a danger to the community, despite being convicted of a lesser charge. He is certainly not a flight risk, and all the reasons that the court considered in releasing him on his personal recognizance still exist today, despite the jury's verdict. I would ask the court to release him on his personal recognizance. With respect to a sentencing date, I would ask that it be set out to sometime in end of June. I think that it would be our request to set over the sentencing as long as this other charge is pending. If the state decides to retry Mr. Thompson on the count 1 charge, then it will be the defense's request to have the sentencing on count 2 pending to see what happens to count 1, because of course it is to the disadvantage to have both sentences held at the same time. And so for all of those reasons, at this point, because of course the state will need time to digest what happened and to proceed on that one, I would ask for an end of June the latest possible.
Mr. Trejo?
Yes, Your Honor, I joined in the comments made by Ms. Coe. And in addition, in terms of a danger to the community, this incident took place 2 years or so ago. During that time, there's no allegations of any violence by my client against any police officer. So that aspect of examining his conditions of release should weigh heavy in his favor. The sentence in itself, there'll be no doubt that we will be asking for a mitigated sentence for a number of reasons, but one being the very obvious, his paralysis and the conditions that he would have to suffer if he were to be incarcerated. For all of those reasons, we'd ask the court to allow him to continue to be released on some recognizance pending sentence.
All right, so taking the second issue first, court will set sentencing at a time that'll be appropriate for the parties and their schedules, and I'll have the parties work with the court's judicial assistant with regard to scheduling sentencing. With respect to whether or not the defendants will be taken into custody today, there is a significant sea change between pre-disposition and post-disposition. That's, of course, the presumption of innocence. On the other hand, these two defendants have had their picture on the front page of the paper probably half a dozen times over the last 2 months. There has been no indication that the court can determine as to, for the most part, between further risks. The court's not going to have the defendants remanded into custody at this point. The court often makes that decision, and the court doesn't see a reason to depart from that decision here under the circumstances. That does mean there's probably some more flexibility on sentencing. And that court is assuming that the diligence that again, with the exception of today, that the defendants have shown in appearing for court every day will be continued to be demonstrated, and that when sentencing arrives, that both defendants will be there promptly for that day. Anything further at this time, Mr. Jackson? No, you actually need a new 3-2 order.
I have one prepared. Usually we do that if the court were setting sentencing. If the court has denied the state's motion for conditions, I don't think, well, I think actually the court does need to enter a new order. I'll prepare that with the previous conditions that they were released on.
And I guess I don't know what those conditions are, but my assumption is I'm not loosening them.
I'm just going to ask the court to impose the conditions that were previously in place.
Yeah.
I will show that to counsel and present that to the court. If there's any argument, we will notify the court. I don't
We
think
don't
there
need,
is.
you're not going to present that in the next grievance.
I can if, I don't have the file with me with the original in it, so that's why I'm hesitating. I'll probably need to either get that or bring it up electronically.
Do you want to present it ex parte?
I can, if all parties agree to sign.
Ms. Coe?
I'm okay with being presented as per.
Mr. Trejo?
No problem.
All right. I will be on the bench at 1:30. All right, anything further at this time, Mr. Jackson?
No, Your Honor.
Ms. Coe? Mr. Trejo?
No, thank you.
This time, we'll be in recess. All right, good afternoon.